Hey there everybody, Bridget Mackay from the law offices of Bridget Mackay here in Petaluma, California. We focus our practice on estate planning and elder law. Here's a question I get fairly often. Can someone contest a trust in the way that they can contest a will? And there's a pretty simple answer to that, and that is yes. Pretty much anybody can get upset about someone's plan. So, having a plan does not stop people from being upset about it when they go into action or feeling slighted or feeling something, suspicious is up. However, the avenues at which to contest either of those are different. If you're talking about a will is going to go into probate, so it will automatically be in front of a judge and in a court. Now, most of us, we try to encourage most people to avoid probate and going to court because it's expensive. But if someone has a will or doesn't have a will and someone's estate ends up in court, then there are opportunities to contest and argue whatever you want to argue about the will in court. From a trust standpoint, those are more privately drawn up agreements, and more privately in the sense of, it's not involved in court to administer. Now, the trustee of a trust still has liability and obligations to the beneficiaries and to the trust itself, and is also governed by the probate code. So there are a set of laws that the trustee has to follow in the administration of a trust. That's why they often hire people like us to help them administer their estates. In a will, you almost are required to have an attorney help you go through the probate process. Now, how do we deal with contestants of either side? They'll reach out to the trustee, typically in a trust, or they will ask for notice in probate if they're unhappy with the will itself or the way that the administration or the distribution and all the different things, T's crossed and I's dotted, that an executor and a trustee needs to do in each case. Now, the people who contest things typically are beneficiaries, right? Or supposed to be beneficiaries. So they are not represented. They have to find their own representation, meaning they either have to represent themselves in this legal field and this legal realm, because laws apply to these two situations, or they have to front the money to hire an attorney in order to fight either of these circumstances, okay? So in my experience, people will make noise about being upset about something, whether it's, grandma's vase went to my first cousin when it should have gone to me, to I've been cut out of this plan and I shouldn't have been, to hey, trustee, executor, I don't like the way you're doing things. You should not have sold the house. I wanted an interest in it. Whatever it is, right? I've heard it all, believe me. But at the end of the day, if you're upset and you're a beneficiary and you want to question something going on, you better be ready to bring it, right? It's going to take you time, money, the hiring of an attorney. So oftentimes, because of those things, what was once an upset will not turn into litigation most of the time. I've also seen circumstances in which there was noise, an attorney was hired, the attorney looked at the trust or understood what was happening in the probate and refused to represent that person any further or contest things further. So it depends. So short answer, yes, it can happen, but also it is actually pretty rare when you have a well-drafted trust. So I encourage you to seek someone who knows what they're doing, is an attorney, and can draft a very sturdy estate plan for you so that your heirs or your spouse are not going to see any noise from beneficiaries.